So once again, warm good morning to all of you. Myself Gayatri and I am an LLM student of Government Law College, Calicut, and I'll be the moderator for today's session. So, moving on to today's session, I'd like to say that there is a quote telling that pen is mightier than sword, right? So exactly that is true when it comes to the life of a lawyer or an academician, because it's the way we use the words that our expressions and our thoughts are conveyed. So moving on to today's session, we'll be dealing with research writing, and without much taking of time, I'd like to welcome two of our chief guests to proceed with the session, and welcome you both.
Thank you, Gayatri. Thank you, everyone. Hope all of you have enjoyed today's session. It's actually a continuation of what we have discussed last day. And more than that, it was only brief. Research is a very vast area, just like an ocean. We just had a handful of water out of it. We were trying to just discuss the fundamentals. So we have given some exercises, two problem-like situations we have given, and some of you had prepared some proposal, write up on it. So today, first of all, we are planning to discuss the same. So I request the presenters, the people who have prepared it, if they are still here, one by one, they can come and just give a brief outline of what they have prepared. Are you ready? I hope they will voluntarily come.
Participants do come forward and volunteer.
Okay, sir.
If they are not ready, I will.
One participant over here, sir. She's coming.
I am requesting. I am just asking. You will love to present it. No, yes or no?
Yes, sir.
You like to present? No issue.
No, sir. It's not an issue.
Come on, briefly.
Myself, Lakshmi Shubhu, and my title of my paper is regarding. Actually, I have chosen the second exercise relating to the religious propaganda during the election campaign. So, since I like to narrow my paper to that specified constituency, my title of the paper is like Need for Regulating the Religious Propaganda in Election Campaign in India, a study with special reference to the election campaign in the said constituency. And I have really made my, I have just noted down around like 6 objectives. Like the first one is relating to how the religion has influenced the people in the country, in the secular country, how it has affected how religion has influenced the day-to-day activities of the people, and also how the politicians has taken the religious freedom for granted and how they have exploited and explored the religious sentiments of the people, and also the technique which has been used by the politicians to really suppress the most burning issues like the welfare measures, the developmental issues, etc. In order, how they have really tried to hide all that points, and how they have actually taken the to address the religious sentiments and given that more importance. And also like now relating to that specific constituency, how the politicians has taken advantage of the dispute over the ownership of the place of worship, and how the people were influenced by the religious propaganda during the election campaign. And also I have figured out 4 research problems like about the degrading concept of secularism in a pluralistic society as in India, and also how the election campaigns has influenced the people to look more into the religious sentiments rather than about the other major factors like the developmental factors and the welfare measures taken up by the by the lawmakers in the society, and also about the judicial pronouncements. Like I have actually looked into one of the case laws of Abhiram Singh versus C.D. Komachan, where it was held by the Supreme Court that religion has no role in electoral process, which is a secular activity, and mixing religion with the state is not constitutionally permissible, wherein in this case the religious propaganda during election campaign was banned by the Supreme Court. And also about the section 123 clause 3 of the Representation of Peoples Act, how far it has helped to curb all these activities during election campaigns. And also relating to the hypothesis, I have made it a point to actually to say that the concept of secularism is really in the diminishing state in the Indian society, and there is a need for upbringing the Nehruvian secularism back to the society. That is to make the people understand about the importance of the Nehruvian secularism, which was followed between 1950 and 1955 in India, and also about to actually look into the provisions of Representation of Peoples Act, whether it is adequate, or should the legislature or the judiciary should actually define the limits and borders of how to demarcate between religious hostility and also the constitutional morality. And also have made certain suggestion, like to make it a point for the to the legal fraternity to make campaigns and to organize programs within the grassroots level, so that the people within the grassroots level, they can understand about the importance of a free and fair election, and how seriously can religious sentiments affect the real problems which has been actually unheard in the society. Thank you, sir. That was actually my research proposal.
Okay, it's good enough. You have done well. Lakshmi, only one suggestion from my side. Arjun, please open the hypothesis slide. Yeah, hypothesis. Lakshmi, if you are asked to summarize the hypothesis into a single statement, having one or two sentences, how will you reformulate it?
Sir, I think I will summarize with 2 points. That is about about the need for relooking to the point of secularism. Yes, that is the diminishing factor of secularism, and also about the legislative and as well as the judicial pronouncements, like how the lawmakers as well as the judiciary should take part in actually imbibing the point of secularism.
We can construct it this way, like religious sentiments are dominating or influencing largely the electoral behavior of the people rather than the welfare measures of governments. So the people should be given proper education about the secular fabric of the country to resolve this issue. It can be a summarized hypothesis. You are just assuming that based on the problem, you are starting your study on this assumption that religious sentiments or religious beliefs are dominating or influencing the minds or the electoral behavior of the people rather than or more than welfare measures of the government. The electorate or the people should be given proper education about the secular fabric of the country to resolve this issue. Does it summarize your hypothesis given here? Yes. Then we will proceed for the study, like you will just read some material review on what is secularism, what is the role of religion in a society. you will have your own understanding about the theoretical part of the problem. Then you will just like the people, the political parties conducting post-poll or pre-poll surveys. You will just, if at all you are able to do that, you will just go for an empirical study and you will prepare a questionnaire about these electoral matters. Like you will have 2-3 questions upon their religious sentiments, 2-3 questions upon the welfare measures of the state. You will supply it to the people and you will collect the feedback. Then you will just have some conversation or interview with some officers like the district collector or other officers, election commissioner or returning officer, such people. Some leading political party leaders also you can interview. Then you can, if at all you are able to do, you can interview some religious leaders or some clergy people about it. And finally, you will analyze the data and you will come to this conclusion. When you come to this conclusion, you will establish the hypothesis that religious sentiments is a dominating factor when it comes to the electoral behavior of the people. Sometimes you may be able to find something more. Religious sentiments do influence, but there are some more factors which are influencing the electoral behavior other than religious this thing, and you will develop your study result based on, and you will come to the suggestions for resolving the issue. By you will speak that people should be given clear awareness about the legal the framework, the constitutional scheme of the secular spirit of the country, and just like you have cited some decisions, the judicial approach to the problem also you will formulate into a suggestion that this should be given prominent importance. The courts also should interfere instead, without waiting for a litigation. In such instances, when a religious leader makes a public announcement about religious sentiments and vote in the line of a religion in the election, the court should act suo motu and just stop the people from doing that. Unfortunately, these days it is not and so open.
Thank you, sir.
Okay, thank you, Lakshmi. You have done wonderfully. You have done.
Thank you, sir.
Very good, very good. Keep it up. Arjun, we can move to the next one. Participant 2, poverty, literate. These are the premises where we have started. It is about the child labor issue, child juvenile delinquency. The presenter is available here. The person who has prepared it.
Participant 2, could you please come forward?
Yes. If at all available and ready, otherwise also we will discuss. If the person comes, it will be very much live. Otherwise, we can go for this. Okay, Arjun. Any research problem or any hypothesis developed out of this? No. You can come to the second slide. No, third one. Next one. Yeah. Come on.
Yes, sir.
Read that slide where it was mentioned. Read it out, Arjun. Arjun, can you hear me? Present it and read.
Yes,
no issue. Present it and.
So the person who have prepared this have divided a synopsis into points. Rather than writing it as a paragraph, she have made it into points. The first point, it's written as parents earn less, low income earners, which prompt children to work and earn money or wage.
Very correct, very good proposition. Okay.
Second point, some children have no parent or guardians, so they have no choice but to earn money for their siblings and for their existence.
Very good proposal.
As income is less, so exists poverty, illiteracy, and ignorance.
Yes, these are supplementary.
Fourth point, cottage domestic production exists, flourishing as the owners pay less to the children, so the child labor exists.
Yes, yes, yes.
Fifth point, drug and alcohol are used as entertainment to forget the hardships of life by individuals.
Drug and alcohol. Final one again, Arjun. Drug and alcohol.
Drug and alcohol are used as entertainment to forget the hardships of life by individuals.
Okay, we can come to that.
Next point, no education related provisions in that particular area, for example, night class, which add to or fuel the intake of drug and alcohol.
Okay, okay, okay.
Next point, the number of schools dropouts is directly related to the existence of individuals. Survival, daily bread winners.
Okay, okay.
Next point, as there is no persons or institution or help, no guidance for a better livelihood or existence, the rate of juvenile delinquency increases.
Okay, 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 okay.
The other next point, the concern authority may come to know about child labor but do not take action.
Concerned authority. Authorities concerned is the right usage. Okay, move forward.
Last point, even though legal aid exists, it does not work within a time frame and unable to curb the menace of child labor.
Okay, okay. So, in this, things to do, that also you please read, Arjun. Things to do.
Research study proposal.
That is about the proposal. Good.
Rational hypothesis and plan of study.
Okay.
Some suggestions for resolution of the issue.
Okay. Okay, there is a legal problem. All the problems or all the premises have been clearly mentioned by the researcher, even though it is not in the formal shape of a research synopsis. All are mentioned. But there is one more point to be added, that we have mentioned in the problem that child labor exists in disguise. Disguise in the sense that it doesn't look like child labor or doesn't properly attract the legal provisions. When you go to the Child Labor Act, you can see family trades or like cottage-like units run by families are exempted from the Child Labor Act. You will see father, mother, children, their parents, siblings, everyone just they together run some small protection unit at home and they all work for it. There even children work. It is not legally an offense. I don't remember the provision. There is an exemption of the Child Labor Act. I am making use of this provision. Actually, the child labor is happening in disguise. The unit will be looking like a family trade, but it will not be really so. It happens in areas like Shivagashi in Tamil Nadu district, where this fireworks industry is so famous. So there, people just employ children in domestic circumstances and they develop domestic units. Actually, the family is not owning anything. The raw materials, the machinery, everything is supplied by a big industrial entrepreneur. And they will supply this to the family and the family will be working on it and they take back the produce and give some nominal amount of it. So their children are prevented from going to there. All these problems went, and only my difference of opinion is about the drug menace. The researcher has mentioned that for forgetting the troubles and hardships in life, people resort to these drugs and alcohol. But actually, it may be so after a point of time. But in the beginning, this drinking or taking of drugs is happening involuntarily. Children or teenagers or adolescents are attracted to this by the elders who use it and who want to use these children for any illegal activity. They just speak about, they just give offers about its uses and its merits. So children involuntarily get attracted to this, and after a certain point they will develop some addiction, and finally what was mentioned by the researcher happens. For forgetting, for relieving from the day-to-day troubles, they resort to it. But to address these, the suggestion given by the researcher is correct, that proper education, children should be given free and compulsory education. As per the law also there are provisions, and this cottage or domestic type of industries must be strictly scrutinized. There should be strict registration process with the governmental authorities, and they should very much clearly ensure that the family itself is owning the establishment, and there should be some ownership documents to be produced, and such kind of strict adherence to the legal provisions and procedures will reduce or resolve it. And what is lacking here is the clear formulation of a research problem or development of a hypothesis in the formal shape. If we wish to construct a hypothesis based on this, we can just draft it like this way. It is only my opinion. Anybody is having any different opinion, we can take it up. The lacunas in the existing legal framework to regulate, to curb child labor are leading to the lacuna in that legislative framework, leading to child labor in disguise in many parts of the country. Proper and strict adherence to legal framework and the constitutional provisions only can resolve the issue, for which the legislative, executive and judicial authorities must act meaningfully. This can be a synopsis when we construct a synopsis in line with the hypothesis we have constructed in the previous problem. This can be a hypothesis for the current problem. The lacuna in the existing legal framework leads to rampant violations of child rights. Proper legislative, judicial and executive action only can prevent and resolve this issue. This can be the hypothesis, and on the basis of this hypothesis, the researcher can start working. He or she can read the literature about child rights, starting from the international conventions, UN conventions, then the constitutional provisions of the country, then the legal provisions, legislations, then law relating to child abuse also, then even recent POCSO also can be a reference material, then books and other kind of resources can be resorted. Then in this kind of a situation, it should be very much taken care that it is not as easy as the previous problem. You can approach the children directly and get the feedback. It's very difficult because the people who are responsible for this child labor like menace, they will very much prevent such agencies or people from approaching them and getting the real picture. So you have to resort to some other means also. You have to go to the authorities and you have to use even authorities. They will just have a connivance with the violators of law. So they don't entertain you for any information. So Right to Information Act can be used. You can just give applications whether this particular establishment, so and so establishments are run by the families of the so and so people. Whether Mr. X is owning the establishment, whether Mr. Y is owning the establishment. Kindly supply the copy of the ownership document. What are the raw materials used? What are the value of the produce? What are the income earned by the family? What are the profit or loss? These kind of questions can give you information. The Right to Information Act is a revolutionary law which made the public scrutiny of administrative affairs or governance affairs very much easy and clear. So this kind of measures you can adopt and you can approach. You will get some information from the affected parties also. Sometimes people may be really worried about their situation, the parents or the children, or somebody will be giving you information. Quite often they will be afraid of giving information. Quite often, but there may be possibilities. And finally, you can come with the thesis and conclusion that this kind of situation leading to this phenomenon. There you may be finding more reasons also. You will explain all, and you will come with concrete suggestions that legal provisions must be strictly implemented, and children should be compulsorily educated. The problems of poverty must be properly addressed. Housing, employment, everything should be given to the family by welfare measures of the society or government. And the drug menace and the alcohol menace should be properly addressed. Governmental agencies like police, excise, even NGOs participation must be very much ensured for dealing with that. And it can produce then wonderful. This way we can proceed for a research study on this topic. Anybody left, Arjun?
Yes, sir. One more
item. It is a written manuscript, a scanned. I hope Arjun can briefly tell what it is. It's about the second problem. Okay, religious. Okay, it may not
actually, she have written on both the.
Any point you find important in that? I think you have read it.
So the thing is that she have written a synopsis, but no research problem or hypothesis is stated. She have referred to various provisions of law. For example, in from the second problem, whatever she have written on the basis of the second problem, she have cited provisions of law like section 295A of the Indian Penal Code.
I'm requesting the other, if around, please come forward and talk about it. There is no need for any inhibition. It will be useful for all of us. Are you there? You don't call by name. Is there any problem, Arjun, with the audio?
There was some problem with Gayatri's audio.
Is audible right now?
Yes. Gayatri, if the person is not around, Arjun, please explain it briefly. we have to move to our presentation part. It's already
so she have written on both the problems, and with regard to the issue with regard to the religious with regard to the dispute with regard to the worship, the place of worship, she have written as synopsis, a brief synopsis. However, she haven't written any research problem or hypothesis. She has stated provisions of law, like section 295A, where it states.
Do you find any suggestion on both the topic? We can focus on that.
She has written that the solution for the problem is to give separate worship places for all the major religions.
What kind? Please repeat it.
There should be there should be an effort to arrange separate worship places for major religions. That's what she have written.
Okay.
She have also stated that the religious sentiments should not be a factor for election propaganda, and people should not give votes by people should give votes by considering the welfare measures or the eligibility of the candidate.
There's her suggestion on the first issue resembles the Supreme Court's verdict on Ayodhya issue. After ruining the country for more than 3-4 decades, the case has not come with the right answer for the question as to who is the real owner of the place. But it has given separate place for worship to both the religions. If it had been done decades ago, the country must have served many things. That is another issue. So it is actually you are reading a problem and you are coming with a suggestion. When you do research, giving separate places of worship for people will not solve the problem totally, because even now there are separate places of worship for people. But there is a free chance that one group will come and claim that the place where the religious, the worship, center of worship of other religions is located is our. It was owned by our ancestors. There is always this possibility. People will come and claim. Because politics or politicians always want this religious sentiment should be burning, should be it should be like there in the mind of the people for their gains. So, proper secular education, as we have discussed in the first problem, proper secular education, that doesn't mean that everyone should be given class on secularism. Secular education is in the sense that constitutionalism, what is the importance of the constitution of the country and what is the rule of law. One should go by the rule of law, and what is the area or the extent to which religion can interfere, and what is the extent to which the constitutional or legal framework of the country can interfere. Just like what we have heard in Sabarimala issue, what we have seen is constitutional morality and social morality. What is the domain of constitutional morality and what is the domain of social morality? So religion should be stopping its reach at a specific point of time, and the constitutional system of the country also giving a space for religious affairs apart. It should not have mixed, it should not have conflict. That's why in the Europe there is a famous saying that what is due for the Caesar is to the Caesar, and what is due for the God is to the God. Caesar the Caesar, Devathinu Devathinu. The statement of Devathinte God should restrict its domain to the extent it can, and the Caesar means the system, the political system, the governance system, the state can just manage its own affairs. But unfortunately, these two things are mixed very much badly in this country, and the problem happens. So proper secular spirit must be inculcated among the people, and it's a very much big process. It cannot be done overnight. The educational procedure, the legal awareness, everything takes time. Generations are to be addressed for resolving the issue. Okay. Now it's time for us to move forward. Today's session is on research writing in legal studies. So I'm happy to see that yesterday's presentation people have found comfortably. In our presentation yesterday, we have spoken about the importance of selection of research problem, construction of synopsis, formulation of hypothesis, and planning of research work, and coming to the establishment or re-establishment of a hypothesis. What is research? That was our yesterday's session. Today we deal with the process leading to the research product. Your writings, your research paper, your article, or your thesis is the product of your research. So the quality of your research should be reflecting in your thesis or your research, right? In every issue, in every problem, the person who is approaching the issue with the mind of a researcher will look into things with a different perspective. That quality and that kind of different, an academically oriented kind of a perspective must be developed out of the research. So coming to the introductory part, legal writing refers generally to the analysis of facts, patterns, and presentation of arguments in a scientific manner. It's not like people casually talking. If in a research writing, if arguments are raised, it should be organized, it should be reasonable and logical. Law does not sit in a vacuum. Instead, it operates in a complex social context. Law is not in isolation. The legal system is to work in the society, and the society is composed of complex issues. It reflects attitude and behavioral norms that control and mold them. So legal system, when we teach our students about law and society, we always tell them that good society will produce good legal system, and a good legal system will in turn produce good society. This is a continuous process. One is to produce the other, and the other is going to produce the former. So it is a very big task on the legal system that it should work in the complex social context and produce maximum good result. Okay. Legal research becomes essential for ascertainment of law. Very important observation. Simple reading will give you an idea about a law, but a research kind of reading, that you will first read the background of the law, the history of the law, the international and national perspectives on a law. Then you will come to develop a kind of different perspective, critically examine the laws in order to ensure coherence. Coherence means proper continuance, consistency and stability of law. Every law is having a history. Take the case of the Right to Information Act. We have been speaking about the freedom of speech and expression, right to information, right to know, right from the inception of the Constitution. Even in the Universal Declaration of Human Rights, this discussion was there. And in many laws and many legal situations or judicial proponents, we have seen this issue discussed. And finally, the Supreme Court has come with the observation that right to information is part of your fundamental right. And then only the law. So the law is not coming on a fine morning. If you simply take the law, the statute in hand and read it in isolation, it's a normal reading. When you go to the background, history, the historical process through which the law has evolved, the purpose, objectives, or the situations led to the evolving of the law, it is a kind of in-depth study. That is a research study. So, social audit of law and the suggest reforms in the law, everything is the task of a research writing. for a research. We can come to the purpose of legal research. Legal research essentially is involved law as a focal point. You can see ascertaining the law, highlighting ambiguities and gaps, determining coherence, stability and consistency, social auditing of law, suggesting reforms. Just in the previous slide, we have mentioned all these are there. And social auditing of law requires proper ascertaining of law. Very good. These are complementary points. If you are not able to ascertain what is the law, you will not be able to socially audit the law, whether what is the performance of the law. Social audit means the study on the effectiveness of the law, whether it has fulfilled its objectives. We will have laws just like debt letter laws. Yesterday we have mentioned about the Dowry Prohibition Act. Now we have 2009, the Right to Education Act has come, now it is 2021. We can see what change the Right to Education has brought about. You will not be able to do it by merely reading the law. You will examine, you will analyze, you will conduct a research study on school admissions, school dropouts happened in this more than 10 years span of time after the coming into force of Right to Education. You will come to a real study. Right to Information Act. It has been enacted in 2005. Now it is more than 16 years old. Yeah, you will see how far it has performed well. You will find that whether it is useful or not, it has come to its objective, fulfilled its objective. Social auditing. Then, if you still find anything to be reformed, you will suggest it. A researcher only is the person able to give concrete suggestions. Otherwise, also people will give suggestions. When you go to the street, people will sit in the bus stop and talk about what is happening around. They will say, this system should change. The system should change. They are suggestions, but not concrete suggestions. How will you change the system? What are the steps for correcting the phenomenon? There should be concrete suggestions. So it is a difference from a speech on the public platform, an open platform, a popular political speech, and a research output. These are different. One can say anything. The former can say anything, but the latter is supposed to say it with clear terms and supportive evidence. Okay. Then types of legal research writing. Descriptive and analytical legal research. Descriptive means explanatory. We will explain things. Analytical means just starting from the research literature review. You will analyze and you will explain about it. Analyze in the sense that when you read about the Marxian philosophy, you will personally, you may be a supporter or opposer of the Marxian philosophy. But your role in the research study is to analyze the Marxian philosophy and to point out its merits and demerits. That is analytical. Their objectivity is very much important. Objectivity means the impartial kind of analysis, the ability to stand apart from the issue and study the issue. Unfortunately, in many issues, even learned people, even scholarly people are just moving to one side and start the discussion. Very bad. Then there will be only two sides. There will not be an objective analysis and real outcome. Just like what is happening in the channel discussions. The researcher should not be like a channel discusser. Should be addressing the problem objective. You can see in the discussions, one is saying that in your rule, in your government rule, this happened. The other person, the opposition party person says, when you have ruled, that happened, that also happened. This kind of counter arguments won't produce any objective discussion and any resolution of it. A researcher should be looking at both, and when something is discussed, he should be focusing on the cause and effect of that particular point. He is not going for countering this with another incident. One sin cannot be justified with another sin. He should address every sin separately and objectively. Okay. Doctrinal and non-doctrinal, yesterday we have discussed at length. Comparative legal research. Yesterday when we have spoken about the literature review, somebody has cited the availability of only online materials, what to do. So we have spoken about comparative research. Our constitutional law, how far it is able to ensure the liberty of people. We will compare it with the American Constitution. What was the American Constitution? What has been done by American Constitution for ensuring liberty of people? We will go to the French Constitution. We will go to the Canadian, or we will go to the Russian, Australian. We will go to many constitutions and see which constitution is having problem with the liberty and what it can borrow from the other constitution to correct it. So this is comparative kind of study. We can move forward. Steps. Yesterday also we have mentioned these things. Identifying the gray area of law. In research upon law, you have to find out the gray area of law. Just like what you have mentioned in the child labor problem today. There's a gray area of law which exempts domestic units, children working in domestic units owned by family from the child labor law. That's a gray area. It should be properly corrected because it leads to child labor in disguise. Then identifying and formulating research problem. Today the first presenter has tried to develop it a good problem and hypothesis formulation, collection of relevant research materials through literature review. Yesterday also we have discussed it. Preparation of research design or plan, research plan, we have discussed. Data collection, different problems warrants different styles of data collection. Some method may be easy in some problems, some it may be difficult. Data analysis. Data analysis is a scientific exercise. In some problem, purely statistical methods can be used. In some problems, statistical and descriptive methods can be used. Like you can give tables, diagrams, etc. And you can give descriptive observations also. Data interpretation, then you are coming to your own interpretation. This has led to this. The figure shows, this shows that. That way you will interpret it. And finally you will develop your report or thesis. This is the process. We have mentioned these steps yesterday also. And for a synopsis, title, we will give the research topic a title. For example, yesterday's problem. If the child labor issue is, you are asked to give a title, you have to work on it. Child labor and child abuse, or child labor in disguise, legal and social perspective. Child labor and child rights, socio-legal perspectives. These types of titles one can develop. Interreligions religions part, in the religions part, one can develop a title like religious sentiments and electoral behavior. Religious sentiments and electoral behavior of the people. A study with special reference to the Representation of People Act, or a study with special reference to the election laws. That way, a title can be developed. So this way, you prepare title. Sometimes a title which is considered proper for one may not be proper for another. But as we have discussed yesterday, shortening, confining, and restricting you to a specific area is very important. Child labor issues and challenges. You may just write a title, but it is a big title, big area. You are not restricting to a certain area. You will be required to study the child labor happening everywhere in the world. You will be going to read content materials. It will be an unending study. Role of religion in election. Influence of religion in electoral behavior. It's a big title. You are not restricting it. So the title should be very much thought about one and very much concise and precise. Introduction of the topic. Here comes the doctrinal part. Your quality of reading analysis reflects their objectives of the research. You will write down what you are going to do with this. Description of the methodology adopted, whether doctrinal research or non-doctrinal empirical study is done or not. Hypothesis, research hypothesis, we have discussed it. Research questions. Somebody can ask questions. How far the child labor laws are implemented properly in the country? How far drug and alcohol menace deteriorate the life of children? How far the child labor and child abuse result in school dropout of children? These type of research questions are also developed. It may not be necessary always, but if one is developing, it is very good. But always remember that if the questions are developed, you should be answering the questions properly in your research. Don't throw away the synopsis once you start your research. Keep the synopsis in the left hand throughout your research work. Then tentative chapterization, maybe tentative only. You will write a thesis and you will just tell in the synopsis that the first chapter will be the introductory part covering the origin and evolution, historical account. Second part will be the international legal perspective, UN and other agencies. Third will be the Indian legal framework on it. Fourth will be the judicial approach to this. And fifth will be the analysis of the empirical study. And sixth will be the conclusion and suggestions. That way, you can just tentatively write down chapters. When you actually go for collection of data and writing of your thesis, maybe your chapterization may vary, but these are very much essential in writing the synopsis. Logical arguments should be logical. Arguments like people are often pretenders. Pretending means keeping something in mind but behaving in a different manner, representing a different thing. This is the statement of Plato about arguments. Fallacious and misleading arguments are mostly easily detected if set out in correct syllogistic form. It is about the reasoning ability of the researcher. If the researcher is having strong reasoning capacity, rational thinking, fallacious and misleading arguments can be easily detected by. This is the strength of the researcher. It is the result of his quality of reading and his strong perspective. So, it may not be easy for all. The statement should be modified that way. It is most easily detected if set out in correct syllogistic form. Syllogistic in the sense that in an organized kind of rational analysis. Quite often the society is unable to have that rational analysis. You will see there are people, even today there are people offering pujas and that kind of offering, that kind of rituals for just curbing the COVID-19 pandemic. So they say that this puja will destroy COVID-19 virus. And these are arguments which are fallacious and misleading. If the researcher is having that kind of rational ability, he will find it out. The personal attribute of the researcher should not be the ground. Like, quite often the researcher also may be a person having strong faith in religious things. If his faith and such kind of elements reflect or influence his research, he will agree with it. It should not be. Rational thinking is very important, and unfortunately, the experience of the society says that your education and your knowledge doesn't have any relationship with your rational thinking. Highly educated people say very much foolish or blunder things and even act or behave so. But a researcher should be analyzing this objectively, and he should be just testing and experimenting, and then only he will be accepting anything. Legal analysis is having 5 attributes, which are 4 attributes, which are called IRAC principle. I, issues, rule, R, rule, then A, analysis, and C, conclusion. Issues must be properly framed, rule must be properly analyzed law, and then analysis, issues must be analyzed in comparison with on the basis of the rule, depending on the rule. It must be cross analysis. Then conclusion. We can simply say, issue says, what facts and circumstances are there? We will come with an illustration that it will be more clear. Rule, what is the governing law for this? When students of law go for writing case comments, these are very much important. You will just find out the facts, then issues, then the law, question of law involved, then analysis. Does the rule apply to these unique facts? There are wrong judicial decisions on many issues because of the inability of the judge to determine whether the particular law is applying to this particular issue. It's a very much different ability. The rational, logical ability of the judge is very important. Conclusion, how does the analysis solve unique observations? Based on this analysis, he comes to the conclusion. Guideline for identifying issue. What facts and circumstances brought these parties to the court in a given case? This is actually speaking about a judicial dispute, not focusing on our research topic we have mentioned in before. Are there words, phrases in the facts that suggest an issue? An issue where the husband beats the wife, usually, whether this is part of normal household activities or whether it leads to any issue which are to be resolved by the judicial authorities or court. What are the facts and whether facts lead to any issue? Then rule. What are the rules applying to that issue? What are the elements that prove the rule? What are the exceptions to the rule? Just in case of child rights, child labor, we will go to the law and find that, okay, Child Labor Act prohibits child labor. but it gives exemption to domestic or units run by families. So you will be confused whether that act applies here. But you should be able to see the real issue. Pretending to be running a family business, the child labor is happening in this case. So the Child Labor Act can very much apply there. Otherwise, the law is a dead letter, because people try to escape by the loopholes of law. So, if necessary, law should be modified. Then, from what authority does it come? Common law, statute, new rule? There are principles, sometimes which even not mentioned in any legislation. People find something as wrong and something as right. Common law principles, like England, you know, they don't have written constitution. They develop law by just judicial process and experimental kind of activities. So that way, every question, every dispute, they have a solution. They don't let any dispute unresolved, citing the absence of a law. They will produce a law. So whether the given issue could be addressed by a common law rule, or a given statute is already there, or a new rule should be formulated. This is a very big good analysis. Then what is the underlying public policy behind the rule? Why this Child Labor Act has come? What is the underlying principle behind it? Subjecting children to hazardous labor is a menace. It is unhealthy practice in the society. Children are the assets, future assets, valuable assets for the society. They should not be subjected to that kind of hazardous labor. This is the underlying principle behind the rule. Are there social considerations? Yes. Social considerations. One cannot simply go there and say that this is an offense, you should stop it. The very next day, this is stopped strictly and people are refraining from that. But what is happening? There will be poverty aggravated. People start committing suicide and crimes will be increased. So you are not stopping by checking the offense. You are just considering the social consequences for it. And you will just go with measures like educating the children, rehabilitating them, and providing the family some other avenue for their livelihood, some employment scheme, some education scheme. So these are social considerations to be taken into account. So that also are important. Which facts, this is an analysis. Now you come to the analysis part. Which facts help prove which elements of the rule? Why are certain facts relevant? See, the fact analysis is very easy for a person who has done a legal study. But for an ordinary person, it may be difficult. How do these facts satisfy this rule? What types of facts are applied to the rule and what are not applied? How do these facts further the public policy underlying this rule? What's the counter argument for another solution? If we go for examples for all these situations, our time may go like that. But each point is as important as it is, and all these are to be considered in the analysis. Analysis actually is the real research process. the data, everything is the raw material. The thesis is the product. And analysis is the research process, the production process. If analysis is not proper, your research product, the thesis will not be of good quality. So every side of an issue and fact must be analyzed. Even minute arguments must be taken care of. Just a judicial decision. The scope for even minor error, minor doubt must be removed. Element of doubt, benefit of this is establishment of the offense beyond reasonable doubt indicates that. Legal research also is such a process. Actually, every judicial decision is a product of legal research. The law is tested with the facts and facts are tested with the law. And the judge's proper ability to analyze, do an analysis comes with the right decision. Okay, when decisions are given wrongly, the higher courts or the review authorities are tested with further research, analysis, and finally a different decision comes. Okay, it's always a continuous process. From the analysis, you come to a conclusion as to whether the rule applies to the facts. The conclusion is the shortest part of the equation. You will say, sometimes your conclusion can be yes or no. In the beginning, you ask a question, whether the loopholes in the existing Child Labor Act gives room for child labor in disguise. This question you have tried to answer through your research analysis. And you are finding, yes, it does. So your conclusion can be yes. Sometimes no. We already told yesterday that sometimes a proposition can be proved wrong after the research. Sometimes you will get supplementary information. Yes, of course, loopholes in the existing law lead to the child labor in disguise, but there are other factors also contributing. Some more factors you will find. But in formal conclusion, you will not stop by saying yes or no. You will be very much supporting your conclusion with so much of your observations. So the reader also must be able to follow you. He should be convinced and he should be given a clear idea as to how did you lead, how did you reach to that conclusion. Yesterday we have spoken about the literary criticism fighter. When somebody reads Kumar Nashan's poetry, Veena proves he sees that it is about the spiritual life of people, the momentary nature of human life. Just like a fallen flower, human life is momentary, and these are the facts. You will explain how did you reach that conclusion. The reader may agree or not agree. The other person may be having a different approach. He may see the fallen leaf, fallen flower, okay. Person thinking different way, he will say, yes, flowers are generally having shortest lifespan. In a day or two, a flower is fallen, and once it is fallen, it will deteriorate and it will mix with the soil. That way he will just like the peripheral technical things of the situation. So he may also try to establish his views by supporting. The reader, it is now left to the reader or the person who looks into your research to decide whether you can agree with it or not. But every research is to produce a result, and that result shall be explained with the supporting evidence or arguments. Okay. Now there is a brief case study on this IRIC process. Karina sues Mohan in a district court over money that says he owes her. Mohan has been owing money to Karina. She sues her in the district court. She wins her case. Mohan appeals the decision in the High Court, which overturned the lower court decision on a technical error. Karina appeals to the Supreme Court, and the court refuses to hear. Now, finally, Karina has lost in the Supreme Court. Final decision. Karina attempts to sue Mohan a second time in the state court system over the same issue of the money she says he owes her. Before we move to the coming slides, can anybody say, maybe learners of law will be able to spot it clearly? Can anybody say what kind of civil law involved here? Anybody? What comes to your mind? This is a situation in which the petitioner, the plaintiff, or the petitioner is trying to sue the defendant a second time on a decided issue. What is
double jeopardy? A bar on suit for the second time.
Res judicata.
Res judicata.
Double jeopardy is a different thing, connected but different. Punishing a person twice for a same. Okay, you are correct, Lakshmi. Res judicata, where we can see whether res judicata applies. Res judicata is in the Civil Procedure Code, which bars multiple suits for a single issue. Does the fact that Karina took her case to the highest court and lost prevent her from starting the same case in a state court? This is the issue. No doubt. Analysis. Your issue, your rule, then your analysis. Since Karina appealed the case to the highest court, a final judgment is considered to have been made on the matter. No doubt. She has exhausted all of her potential appeals by going to the highest court, which has ruled on her case. Clear. If she attempts to bring the same cause of action, that is, same particular facts and controversy in the state court, Mohan can argue to have the case thrown out of the court using the principle of res judicata. In a bare analysis, we come to the fact that this is a fit case for applying the rule of res judicata. So, Karina cannot bring the case in the court, in the state court. But you will not stop your conclusion in the single line. This is for brevity in the presentation, we have wrote it like that. But finally, you will speak about res judicata at length, and you will convince the reader as to how the principle of res judicata is applied here. So, a legal research is something which can be properly done by a real learner and analyzer or analyst of law. A legal analyst, a legal learner only can properly do a legal research. Legislative process should be the outcome of a legal research. Judicial process should be the outcome of a legal research. And even executive actions, see, much thought about executive actions are seldom rejected by judicial authority. However, executive authorities who do not understand the real intention of the legislature act differently and land in trouble. Even executive actions must be a much thought about action coming out of the mind of a researcher. So we can move to the writing part. These till now we were just speaking about the construction of ideas, analysis, and formulating, or we are just readying the ground for research writing. Now we are actually starting to write. I request Arjun to take forward it in the same route. Arjun, are you there?
Yes. Hope all of you can hear me. If you have any doubts, please stop me in between and you can ask the doubt. I'm starting from where Sir have stopped, and I will be using examples which was discussed in Sir's presentation. So yesterday I have asked you to go through newspapers, and I have already told you that it will help you in developing your ideas. Hope you have gone through the newspapers. At least I hope you have decided to go through newspapers, at least from yesterday. Have you? Have any of you? Because recently in today's newspaper there was an issue with regard to overcrowding of prisons during COVID-19. And the Supreme Court have directed the state to reduce the number of prisoners in the jail. So this is an issue which you can work on. So that's why I asked you to go through newspapers to develop your ideas for writing research paper. So moving on to our today's topic, and I will stop really soon because we are almost, it's almost time to stop the presentation and we will entertain the questions. So while writing a research paper, there should be an absolute flow means there should be a flow of ideas, there should not be inconsistencies, and there should not be contradictions. When Sir was discussing the last example, when he asked you as to whether any of you know any principle that is applicable in this particular case, some of you said, told about the right against double jeopardy as a principle which is applicable in that particular case. Can you say that why is it not applicable in that particular case?
Double jeopardy is applicable in criminal cases.
Only in criminal cases. That is first point. Secondly,
again,
if a person is
that
set
person
free,
should not be prosecuted again. But here the case is
if a person is set free in a criminal case, can the same case be launched against him at a later point of time?
if he is acquitted, then it cannot be.
If he is
Acquitted after prosecution, he cannot be.
even if he is acquitted, he can be prosecuted again. Only if he is convicted, he cannot be charged again for the same offense and he cannot be prosecuted again for the same offense. If he is acquitted, he can be tried again for the same offense. Go through the provision.
Acquitted after prosecution, still can he be tried?
Yes. If you have doubt, if any of you have constitution, please go through Article 20, the part where it talks about right against double jeopardy. So now I'm not going into that portion, but these are the two reasons why, because of which that principle will not be applicable to the case which was presented before you by Gireesh. I hope you can see the slide. So, hope it is visible. Can you hear me?
Yes, it is visible.
So, the major factors that has to be considered in legal research is that there should not be any inconsistency or there should not be any contradiction. If you are bringing in ideas which are contradictory to the established legal principles, then it is not a proper legal research. There should not be inconsistency of ideas. At one place you're talking about something and at a later point of time you're talking about something else. then that is not a proper legal research. If you are talking about the issue of child labor at the beginning of the paper, and later you're talking about the issue of child rights and the rights of children against sexual exploitation at a different part of your paper, then there are expression of different ideas in the same paper. The paper you're supposed to talk about the issue of child labor, and you're addressing a different issue. You're citing different case laws. So while writing a legal research paper, you should be writing to the point. You should not be inconsistent. You should not contradict the facts which are being presented before you. Again, there should not be repetition of ideas. If you have said something in a paragraph, and if you are repeating the same idea again in a different paragraph, then that does not make any sense, because you have already presented an idea. You're supposed to develop that idea further. You're supposed to bring in new ideas in the coming paragraphs. And even if you're bringing in different ideas and different ideas that have sufficient legal backing, remember the fact that you are not an authority, and you need to support your ideas based on the authorities of law, which can be a case law, which can be the court of a jurist. So you should be able to support your idea. It can be a legislation. And here comes the relevance of footnotes and unnecessary things which affects the writing process, or affects the research writing, or affects the flow of the ideas, should be avoided. If you are talking about child labor, issue of child labor in India, that is a very broad topic. You should be able to narrow it down, as already stated by Sir. You should be able to narrow down your topic so that the topic is not too broad. So if you are talking about child labor in the firecracker industry in the state of Tamil Nadu, you should be able to focus yourself to that particular issue. You should not write about something else which is happening in some other part of the nation. You can compare, you can bring in comparative studies, but remember your topic, remember your objectives, and limit yourself to that particular area. Secondly, there should be rationality of order of presentation. So all of you know that while writing, regardless of what you are writing, there should be an introduction and there should be conclusion. There should be a head, there should be a tail. In Malayalam we will say, no, talayum valu illade ezhudha ennu parayathalle. So there should be a head and there should be a tail. Okay. So without that, whatever, even if it is an answer which you are writing in your exam, there should be an introduction, there should be a conclusion. There should be a flow. There should be a jurisprudential theory to deduce its relevance, then how it is related to the idea which you are going to discuss in your paper, and then you should be able to conclude. So there should be an order of presentation of ideas, and you should also check that whether the idea present in each paragraph, what is supposed to represent a single idea, and the paragraphs which are coming after the first paragraph is a continuation. There should be some relation. That's how you're supposed to develop your paper. Each paragraph represents a particular idea, and some paragraphs might include more than one idea. If it is so, consider after writing the paper, consider.
Just a second, Arjun.
Yes.
Arjun.
Yes.
Gayatri, are you there?
Yes, sir, of course.
My friend from Kerala University, Mr. Sri Kumar, is attempting to join. Okay, please allow him if he is planning to join.
Yeah, sure, sir. Sure, sir. Sure, sir.
So there should be each paragraph represents a particular idea, and there should be a connection between between each paragraphs in your research papers. And if there is more than one idea, which is if you have included more than one idea in a single paragraph, then after finishing your paper, you should consider whether there is a need to divide that paragraph further. Whether you need to shift an idea which is presented, there is a need to shift idea which is presented in one paragraph to another place. So that needs to be considered. There should be coherence. What do you mean by coherence? Coherence means logical presentation of ideas. Logical presentation of ideas. There should be some logic for each of the argument that you are raising. There should be some connection. There should be some unity. So in a research paper, you are arguing or you are trying to bring in a single idea, a broad idea, and you're trying to justify that broad idea with the smaller or narrower or smaller ideas. You're trying to represent a broad idea with smaller ideas, that you bring in through each of your paragraphs. And understand that there should be coherence of the ideas that you are presenting in your paper. There should be unity of ideas. There should be connection. Paragraph-wise coherence should be maintained.
Arjun,
Yes.
coherence can be cleared by an example. When a person is speaking about child labor, he starts with a paragraph like this. Child labor is a big issue faced by societies all over the world. It is attempted to be addressed by international legal initiatives as well as domestic legal framework across the globe. And the person says, Indian film industry is very much curtailed and controlled badly by censorship, which prevents freedom of speech and expression to a great extent. So what is the problem with these three sentences? The audience or the readers were thinking that the person is seriously speaking about child labor. But after starting on it, the person just deviates and go to something different. He doesn't have coherence in his ideas. So he may be having something to speak about child labor in film also. After 2-3 sentences, he may come to that in the cons of film, the child labor scenes were tailored by the censor board. Maybe he may be saying so after 2-3 sentences. But the beginning 2 sentences do not match with the 3rd sentence. So one should be moving from one idea to a related or different idea very much slowly and with clear demarcations. In this paragraph, he should be speaking about the global child labor issue, and in the next paragraph, he can start with child labor is a big issue addressed by the Indian film and literary sector also. Then slowly he can speak about curtailing of freedom of speech and expression by the government by censorship of scenes depicting child abuse and child labor menace. So this is the problem to be addressed. One should be telling X in a first sentence and then an extremely different Y in the next sentence. It should not be like that. It will result in what we view in our channel discussions this evening. There are people who, when something is asked, something is asked by the person, the discussant will be speaking about a completely different thing. And he will say, I am coming to that, I am coming to that, but he will never come to that because he has nothing to say on that point. So he is trying to escape from it. So this is paragraph in coherence within the paragraph and coherence between paragraphs. Okay, first paragraph you spoken about global child labor menace. Second paragraph, you should not speak entirely different about entirely different thing in the second paragraph. Such paragraphs won't form the part of a good research writing. For example, first paragraph you have spoken about global child labor menace. Second paragraph you are speaking about our second research problem, that is this electoral behavior of people on religious sentiments. These are having no connections. These are products of scattered thinking and irrational analysis. This should be avoided. Coherence, when you read an academic book or even a fiction, a novel, a poetry, only if there is coherence, the flow, the right flow, you will be involved in that. Even when you listen to a musical program or a song, or even when you watch a film, you will face this problem that if there is no coherence, no proper flow of ideas and events, you will not be able to follow it. That way we can proceed. Okay, Arjun.
Okay, as Sir have said, whatever it is, whatever you are writing, there should be a connection of the ideas that you're trying to present in your study. Basically, your research study, through your research paper, you're trying to bring in an idea before the academic fraternity, and you're trying to justify that idea. And if there is no proper flow of ideas in your paper, then it will be, you will not, first of all, you will not be able to rationally convince the reader or the listeners before whom you're trying to present your paper. Secondly, no one will be able to, even if a person is trying to understand your paper, even if you're trying to explain it to them, they won't be convinced. So the main issue that is faced by first-time researchers is that they are not able to structure their ideas in such a manner as to make it convincing, in a convincing manner. They struggle to make struggle to present it in a convincing manner, and that should be taken care of by the researchers while writing a research paper. There should be legal content. Realize the fact that you are not doing a social science research. Means though law comes under the broad term of a social science, law deals with legislations, case laws, rules, orders, protocols, etc. The opinions of various jurists. You should be able to incorporate all these in your research paper. What the society thinks or what the layman thinks, it can be included, but that should not be the only basis of your paper. What you think is of no relevance, what you think will become relevant when it is supported with sufficient judgments, sufficient precedents, sufficient legislations, and correct provisions of law. then only your paper will be of value. That's why it is always advised not to use I terms like the terms like I, you, we in research papers, because you and I are not relevant. What is relevant is the law and the logic of law. That is what you're supposed to address. So instead of I, you can use once, O-N-E-S. You should not use I because you are not relevant. You should not use you because another person is not relevant. What is relevant is the law. And you can address the community as a whole. You can address...
Arjun, one can say, I observe, instead of I observe, instead of I think, one can say it is noticed that, it is seen that way in a third person reporting speech, one can proceed. That
also you can use the term researcher. The researcher in this paper intends to study. The term researcher will give some amount of value to that particular statement, because researcher is considered to be unbiased. Researcher is considered to have taken into consideration all scientific factors of research. So you can use that term, but still you can't use the terms like I, you, we. Remember this. And there should be a reflection of author's perspective. Reflection of author's perspective means you should be able to analyze whatever you have stated in your paper, and you should be able to present it in your manner. So for example, there was recent controversial in 2018. There were 3 major controversial judgments which are passed by the Supreme Court. So there were opinions expressed by various judges. If one is writing a research paper on the Sabrimala Indian Young Lawyers Association versus the Union of India case, which was passed by the Supreme Court which was delivered by the Supreme Court in the year 2018. Merely citing the opinions of judges and merely stating the opinion of the Supreme Court, or merely stating the ratio of that judgment as your conclusion, won't make your paper a research paper. That will be more of as the summary of that particular case. Only if you are able to criticize or critically evaluate or critically justify the stance that were taken by the judges in that particular case, you should be able to think, why have the judge made such an opinion, made such an observation in this particular case? Then only it will be of the level of a research paper. Footnotes, it is of high relevance. Without footnotes, your research paper, the paper won't be considered as a research paper. The value of the research paper is always considered on the basis of footnotes that you're giving, or on the basis of the authorities that you're citing. So if one is citing so many sources, so many online sources, like Wikipedia, Legal Services India, the fact is that you have footnotes, but the adequacy of that footnote or the relevance of that footnote is doubtful, and your paper won't be considered to be a good research paper because of the bad sources that you have cited. So you should be able to cite relevant sources. There should be a purpose for citing the sources, and format should be followed. Usually in legal research, the format that we are using is Blue Book 20th edition. The most recent edition is Blue Book 20th edition citation format. However, certain places like that of Indian Law Review, Indian Law Institute Review, they have their own citation methods. So generally, while writing a research paper follow the standard format. That is the blue book format.
Arjun, if time permits, we can take another 10 minutes for just showing that blue book citation you have kept into folder.
Sure, sir. Sure, sir. So basically, you should be able to follow the standard format. But if the place where you're going to present your paper, or in the place where you're going to submit your paper for publication, demands that your paper, your footnotes should be in a particular format, follow that format. But ensure that the format is followed. The research, there is a reason for following that particular format, because it will be, even if one another person is referring to your citation, the other person will be able to know as to which source the author is referring to, or who is the author of the source which the author is referring to. Because there is always a standard format. The name of the author is mentioned first. Sometimes the title is given in italics. Page number is mentioned. So any person who is referring to your article, research article, will be able to check that the sources you have referred to. And beautification, it is very important in research paper. The reason for this workshop to happen, if means one of my friend Gayatri, Gayatri called me and she asked about how to arrange her research paper. In what format should that research paper be? She asked me the same. It is also very important in the research paper. While writing a research paper, the format should be followed. Usually the format followed is Times New Roman. If it is a title, it should be of 14 size. It is represented in uppercase letters, and it should be bold. It should be aligned to the center. Body should be in Times New Roman. Font size should be 12, and line space should be 1.5. Subheadings, Times New Roman. Font size should be 12. It should be bold. It should not be in uppercase. It should be in sentence case. Subheadings. Usually it is in sentence case. But if the place where you are submitting your paper, if they ask you to follow a different format, go for that format. Usually the format which we follow is that the subheadings should be in sentence case. It should be bold. I was a person who used to use uppercase letters for the subheadings. But when I submitted my dissertation, Gireesh sir was my guide. He went through each and every page. He made the beautification for that. So if that is the term to be used, he arranged that entire research paper. It should be presentable. While doing something, while writing a research paper, the research paper should be presentable. The person who is looking at that paper, there should not be any aversion in the mind of that person who is reading your paper. And for that, it should be arranged properly. The footnotes should be in Times New Roman. Font size should be 10, and line spacing should be 1. And generally, author's details are also given at the very beginning of the paper. Instead of using numbers, the footnote numbers, you use either star symbol or hash symbol after the name of the authors, and you can write your designation, your contact details. Thank you. That's it. And if you are ready, I can show you.
Okay, you can simply show and read it only.
20th edition.
I think there may be some people may be having some doubts as to some point, then only we will explain. Otherwise, you can read it one by one.
Sure, sir. And also with regard to the provision which we were discussing at the beginning of this class, beginning of my class, I have given it in the chat box. Article 20 clause 2, what does it read? So I will just read it and I will move to the blue book citation. Article 20 clause 2 reads as no person shall be...
Actually, I confused it with section 300, like star
Yes.
PC.
That's fine. That's completely fine. What I said is that, so you should be able to read the provision. You should be able to understand as to what that provision correctly says. Now, I know many people who don't know what the provision actually says. Everyone know that Article 20 provides and talks about the right against double jeopardy, but they don't know what it actually means. If the question is asked as to whether a person punished, can he be tried again? Whether a person who is acquitted, can he be tried again? The provision is very clear. So you should be able to, the point is, while representing your ideas in your research paper, you should be able to analyze the law. You should be able to understand what the law actually means. Then you should use that law. So we'll move to citation format. Hope it's visible.
Yes, it's visible actually.
Citation format for books. First, you have to cite the name of the author in bold letters, in capital letters. Then the name of the book, page number, then the publisher's name and the year of publication. Then, if there are multiple editions by the same publisher, then it is a different citation format. Name of the author, then the name of the book, then the page number, then the edition and the year. Cases, it's generally the same format, name of the case and the citation. So if you are referring to Manupatra, there will be separate citation. The usual citations that we use are AAR and SEC, but if you are referring to Manupatra, there is Manu citation. Manu, and they will give one number. That will be your citation. Statutes, while citing statutes, use this format, the name of the act, the year, section which you are referring to, and the number of the act and the year in which the parliament have passed that particular act. Constitution, this is how you are supposed to cite the constitution. Article, the article which you are referring to, the clause of the article that you are referring to. Then for citing articles, it is a separate format. The name of the author is each word, the first letter is capital. The first name of the author, the first letter is capital. The second name of the author, or the last name of the author, the first letter is in capital. And the name of the article is given in italics. And then you will cite the journal along with the page numbers and the year of publication. And the online sources, if you are referring to a website without the name of the author, it is one, they ask to give one form of citation. If it is dynamic web pages refer to, for example, Legal Boffin is a dynamic web page. It is a blog. So separate citation should be used. If there are certain websites that give you PDFs, if you click on that website link, a PDF will get downloaded. So that should, if you are using such a source, you should use this format. And if you are citing a direct internet source which have given the date of publication of that particular article, then you should use this format. For example, if you are citing the web page of Hindu or The Wire, then you should use this format. The date of publication and time of publication should be mentioned. Thank you.
Only one point I want to add. When in Arjun's presentation, there is something mentioned about legal content. The legal researcher should be very much taking care about it. Many of our students come with good research topics and good research outputs, but the problem is the problem does not have the research, the work does not have any relation with the legal framework or any law. Maybe social issue, political issue, economic matter, that kind of thing. So when in legal research, in every issue, you should be relating it with the legal subject or legal framework. For example, in our child labor problem, we have Child Labor Act and it has to be related. A sociological researcher can just say child labor is rampant in the society owing to poverty, illiteracy, ignorance, drug menace, alcohol abuse, etc. It should be addressed by giving proper education, by providing welfare measures, welfare, employment, poverty eradication measures, etc. In the entire thesis, even though it is a very good research, in the entire thesis, there may not be any mention about the Child Labor Act or the role of legal system in curbing the child labor. So, but when you, as a legal researcher, when you do a research, you should be very much be able to relate with the legal system and to locate the law touching the issue and comment and analyze and comment properly on the legal points. Okay.
So just one more thing. While writing, while in the body of the paper, while mentioning articles, the first letter of the word article should be in capital letter. While mentioning sections, section 5 of IPC, S should be in capital letter. Otherwise, there is no difference between the article which the article. What is the meaning of an article?
Article means a write-up.
Write-up. It can mean a write-up. It can also mean a provision in the constitution.
Yeah.
So to represent that, the first article A should be in capital letter. Section S should be in capital letter. While representing the laws, each word should begin with capital letter. In the Indian Penal Code, I should be in capital letter, P should be in capital letter, C should be in capital letter. Because this is one of the general mistakes which is made by researchers in their paper. That's why I mentioned. Thank you.
In research writing, there are many things like that to be corrected, but once it is being done only, throughout the process only, it is getting corrected and corrected again. And final correction is always a dream, because perfection may not be always the result. Even we were like the renowned filmmaker Satyajit Ray, if after 10, 15 years or 20 years, if he looks back to one old film of him, he himself will say that he would have made it is better in some different way. That way, things are seeking perfection always, just like human minds. Okay, Niranjana, we can just call for the comments or observations or queries, anything?
Yes, sir. We do have one question typed by Deepthi Pudyaveetil. And other participants, I request you to kindly turn on your mic if it's comfortable for you and to bring forth the questions if you have any. So, can we proceed with Deepthi's question, sir?
Yes.
So, Deepthi is asking about chapterization. So, her question is, often chapterization seems to be very tricky. So, are there any tips to improve the quality of chapterization?
There is no hard and fast rule regarding chapterization. We quite often direct or instruct our students to go for a particular scheme of chapterization based on our training. How did our teachers train us? How do you begin with the thesis? Normally we start with the evolution, the origin, the historical account of a given issue. That is mainly we speak about it. However, there can be topics on which the contemporary situation can be the first chapter. In the second chapter, a person can go for historical account. And sometimes we then move to the international legal perspectives, and next chapter will be the domestic legal framework. However, in certain topics, there may not be that much of international legal relevance. Just like religion and electoral behavior. International law has 2-3 conventions on religious practices, but there is no straightforward convention or covenant speaking about election behavior and religious sentiments. But when it comes to child labor, we have international conventions on child rights 1959 as well as 1989. So the international law, UDHR, then ILO, many. So this, depending on the topic, one can go for different styles of chapterization. For any trick or a tip, because we are conventional people, I am belonging to the conventional researchers generation. So I may be doing it this way only. Conclusion, and when you reach conclusion, I tell my students, don't title it conclusion and suggestions, because that term indicates that you are having some authority to suggest. You can simply say conclusions and suggestions for reforms in the area. Your suggestions may or may not be considered. It's your view only. It should not be always acceptable for the other party, your suggestion. And this way, we just do some, some nurturing, some soaping only. So Arjun may be having some more insight to it, because you are a new generation researcher.
I just want to say that whatever we have said here is just the theory of research, like theory of swimming. If you want to learn swimming, you should actually enter the water. So if you want to learn research, you should actually start researching. You should actually start writing research papers. As during my LLB days, I haven't written a single research paper. I started researching after coming to Department of Law, which there was enough time for us to research. There was enough, means not free time as such, but there was enough time for us to do our co-curricular activities. And what I focused was on research. So when I started my writing, it had its own flaws. My grammar was not that perfect, but I had problems with regard to I had doubts like this. How should I go about? How should an abstract be? How should the keywords be termed? But I did not go behind any person to learn it, but I tried to write it. I tried to present it at various seminars. I received number of criticisms. As Sir said, whatever suggestions which we are raising in our research paper might not be acceptable for another person. But at last, you will refine yourself. You will be able to improve yourself. That's what happened. So basically what people used to do is that they will write 1 or 2 research papers. They will receive some criticisms from others and they will stop writing. They will stop trying to publish their papers. When we send our papers for publication, mostly we will receive rejection letters for the first 1 year. And I had a dream of publishing one of my articles in Hindu. But I have never dreamt, I have never thought that it will come into a fact, or it will be published in that particular paper. But it got published. So what I did was I didn't send it to Hindu, considering the quality of that particular paper. I was doubtful about myself. I didn't send it to Hindu. I forwarded it to all other newspapers. All other newspapers rejected it. And at last I forwarded it to Hindu. Just let me forward it. That's what I thought. But they accepted it. So the thing is that you should write again and again. But there are some ground rules that you should follow. People think that they can write anything. That is not acceptable. There are some ground rules. There is some format. So you should observe the format. There should be citations. Citations should be in correct format. Your papers will be rejected on the basis of wrong citations, incorrect citations. Citations should be one of the important things that you should consider. Then the most difficult thing is to develop an objective approach to research. means keep aside all your bias. That is one of the difficult things that a researcher will face while writing research paper. So this is the words of Gireesh. When I used to talk to him, he used to tell me that it is the most difficult thing for a researcher to do. So he gave me an example. Consider that you have a sibling in your house and both of you are playing with some other children and your sibling have committed something wrong. You will always support your sibling. And even though that person, your brother or sister is wrong, you will support your sibling. No, a legal researcher cannot be so. Now, I might be having my own religious ideas. I might be having my own political ideas, but I should not write it in my research papers. That's it. Thank you.
Okay, so balance, patience, and objectivity. These are keywords to be kept in mind. One more question, I think, has come. Gayatri?
Yes, we do have one more question, and it's from Anushree J. Anushree is asking, so when lack of sources shall force a researcher to make changes in the synopsis or idea, or even the hypothesis, we have said before, especially on topics in which much research has been already done, for example, space laws, etc. There are articles, but not what we are looking for. So how do we address and cope with such problem of lack of resources? That's a question from Anushree.
It's a very important question. Whenever our students come with some topics for research, we first look into this part, availability of resources. If we did not mention clearly about this in our presentation, it was a flaw. In yesterday's presentation, it could have been mentioned. Availability of resources is a very important point. For example, when you try to research on human rights violations within the armed forces, not by armed forces. So you will plan to go to an army base and collect the feedback of Jawans, Sepoys, and you will go to the records in a court-martial office. What is the way of trial? Whether the trial in a court-martial is happening fairly? What is the justice delivery mechanism happening inside? Your research topic will be very much beautiful, very much worthy, but you will not even get a single piece of material, because you won't be able to enter the army premises and they won't allow you to collect data. They will never give you any material. Even if you file RTI petitions, they will say this is strategically important defense documents, it cannot be done. Similarly, in case of human rights violations happening inside prisons, very difficult to enter prisons and collect the feedback or the response of prison inmates. And even if you are able to enter in and speak to them, they won't give you clear and factual details because they are afraid about the authorities. So availability of resources is a very big issue. One should be selecting a topic based on which is capable of having good availability of resources also. But there is a problem. Availability of resources is our problem. But doesn't mean that people inside the army, people inside the jail should undergo these human rights violations always for that reason. A very, very, very touching question. So in such situations, you can see there are investigative journalists extract information through some other sources, but may not be authentic for a researcher. There may be different mechanisms operated by different people, but a researcher study is restricted there. Unfortunately, we have to accept. And Anushrie's question has another side also. She is speaking about reducing the topic or modifying the topic in accordance with the availability. Yes, it is correct. One should be like, even though he starts with starts with this a topic, and starting through when she or he has begun the research, it is found that it is very difficult to get materials. So it has to focus on a different area, an area within the topic, but a minute area. So it happens when a person is doing research on the success and failure of alternate dispute resolution mechanisms. There are many alternate dispute resolution mechanisms: arbitration, conciliation, negotiation. You approach big companies having arbitration mechanisms, they do not give you any material. So arbitration, and in many areas you may not be getting materials, but in areas like Lok Adalat or this kind of similar mechanisms, there may be materials available. So you will then just modify your title. Effects or success and failure of Lok Adalat, effectiveness of Lok Adalat, a study with reference to so and so district or so and so state. That will just modify or reduce or confine your topic to a certain specific area, and you will be able to get good resources and you will become able to complete study. So depending on the availability of resources, one should be modifying or reducing or confining the topic also. And now there is an adventurous way out left, that is, try some different ways out for obtaining materials. Like we will just tell a different purpose. We need this document for this purpose, but we do make use of this for research. But it's not the correct way. That is actually the way of these investigative journalists or other people. We, being researchers, because we have to validate the sources also. So the sources, if not we are obtaining resources in a straight manner, we may not be able to validate its genuinity. So confining, shortening, modifying research topic as well as title is the safest way to tackle the problem of availability of resources. Anushree, are you happy?
Yes, sir.
Oh.
Thank you so much, sir, for the explanation and giving us a detailed description of how we should proceed with research. Are there any more questions, participants, from your side? I think, sir, we are done with the question session, sir. So now, so I thank both of you very much for patient listening of all our questions and answering the same. Now I'd like to welcome our student, 3-year student, Mr. Jishan, who is also an alumni of Central University of Kerala, to give the official vote of thanks.
Okay.
Thank you, Gayatri. I think I am audible.
Yes, Jishan, you are audible.
Hey, good afternoon, one and all. Okay, thank you. Hey, good afternoon, one and all. As an alumni of Central University of Kerala, it's my privilege to propose vote of thanks and acknowledge the contributions of resource persons on behalf of the team Legal Boffin. Let me get on with my duty without further delay.
From which department, Jishan? You are social work?
Sir, economics, sir. Economics, 2016-18 batch.
Oh, good. Okay, carry on.
So we are thankful to Dr. N. Krishna Kumar, who inaugurated the workshop and being with us throughout the session and as a supporting faculty. On behalf of Legal Boffin, I would like to express our sincere gratitude to Dr. Gireesh Kumar J, Assistant Professor, Department of Law, School of Legal Studies, Central University of Kerala, who spent his busiest time and enlightened our minds and shown us the way how to approach research and writing in the field of law and legal studies. Thank you, sir. In addition, we are grateful to Mr. Arjun Phlip George, Research Scholar, Department of Law, Central University of Kerala, for his effort to the successful conduction of this workshop and sharing your valuable thoughts and understanding that we should keep in mind forever while approaching legal research. Thank you, sir.
Thank you.
I would like to express our sincere thanks to all participants who sincerely attended this session and enlightened. I would also like to thank you to Gayatri CH. She is our teammate, but for her hard work to conduct and successful completion of this workshop. She is the leading force behind this workshop. Last but not least, I express my love to the entire teammates of Legal Boffin, Dr. N.L. Sajikumar, our guiding faculty, Niranjana K.S., project head, and all editors of Legal Boffin for their hard work and teamwork for the successful completion of this workshop. Thank you all. Thank you.
Before we end, can I say one more thing? Before we end?
Yeah, sure.
So we were talking about research writing, and all of you might be interested in publishing your paper at some places, no? So there was a request from the side of the organizers to give an advice as to where to publish these papers. So my advice with regard to that particular question is try for small blogs like that of Legal Boffin. Okay, try sending them the papers. Try to publish small articles at the while you're beginning your research, because at the beginning stage you might not be able to write a proper research thesis and send it to some governmental authorities and get it published in their reports. So start from the very base. Try to look for the platforms like Legal Boffin. Try to get your small articles, small research articles ranging from 700 to 1,000 words. Get it published, then go for bigger articles. Try to make presentations in national and international seminars, and then go for journals. Thank you.
Okay.
Thank you so much,
University, and need to express the sincere thanks for making both of us in a part of this, and wish all the success for the organization. I feel we can organize big events in future, national or international seminars, and I'm very much happy that it is from the Calicut Law College, because in the law colleges in Kerala, I didn't visit personally, only the Calicut Government Law College. Yes. So I am very, very much happy, even virtually, at least virtually, we are able to be part of and endorsed by the Government Law College Calicut. So happy about all of you. Thank you all.
Thank you, sir. Thank you so much.